Alright folks, let's talk Pakistani law, specifically the Qanoon-e-Shahadat Order of 1984. Now I know what you're thinking, Munir, law on my Friday night, but trust me, this is actually interesting. It's all about the things you don't need to prove in a Pakistani court. Because believe it or not, some things are just so obvious, so universally accepted, that even our legal system is like, yeah, we get it. We're talking about Articles 111 to 115 people. These bad boys laid down the law on what we call judicially noticed facts. Think of it like this, common sense, but make it legal. It's all about streamlining the system, avoiding those moments where some lawyers like, objection, I demand proof that the sky is blue. So buckle up, my friends. We're about to dive into the wild world of Pakistani law and explore the fascinating realm of facts so obvious, they're legally undeniable. We'll be looking at real cases, breaking down the why, the how, and the you gotta be kidding me of it all. Let's go. First up, we've got Article 111, the OG of judicially noticed facts. This is where the court flexes its I'm not stupid muscle and says, look, some things are just common knowledge. We're talking about things like the laws currently in effect, official government gazettes, because even the government needs a newsletter, court rules, regulations, you get the picture. It's about stuff that's documented, established, and as they say in the biz, beyond dispute. Like imagine having to prove that Islamabad is the capital of Pakistan every time it comes up in court. That's where Article 111 steps in and says, now we good. And the best part, there's case law to back it up. Take the case of Government of Pakistan versus Syed Anwar Ali. Back in 1955, it was a whole border dispute thing, very tense. But when it came to the actual territorial limits of Pakistan and India, the court was like, next. They took judicial notice, meaning they accepted it as fact without needing someone to roll in a giant map and be like, see, this line here, it just makes sense. Next up, we're talking admissions, people. Not the I confess, I ate the last samosa kind, although those can be equally powerful. We're talking about Article 112, where the name of the game is facts admitted in pleadings. Basically, if you've already admitted something in court, you're kind of stuck with it. Think of it like this, you're in court arguing over who ate the last cookie from the jar. You in a moment of weakness blurt out, okay fine, I ate the cookie. Well, guess what? You just admitted to cookie theft in the eyes of the law. No need for a crumb analysis or a dramatic reenactment. You said it, it's on the record, and unless there are some seriously extenuating circumstances, that's that. And wouldn't you know it, we've got a case for that. Ahmed vs. Muhammad Aslam, a real nail-biter from 1995. The court basically said, look, if both parties agreed on something earlier, we're not going to waste everyone's time rehashing it. Efficiency, people, it's a beautiful thing. Alright, let's talk about bureaucracy, baby. Because nothing says irrefutable truth like a dusty old government document. That's where Article 113 struts in, all about facts concerning public records. We're talking birth certificates, death certificates, the OG paperwork that dictates the beginning and, well, the end. These documents, my friends, are the VIPs of the evidence world. They get a fast pass, a backstage pass, the whole shebang. Why? Because they're maintained by the government. And the government, in theory, doesn't mess around when it comes to record keeping. So if your birth certificate says you were born on a Tuesday, well, by golly, you were born on a Tuesday. No need for your mom to dig out that old baby book. And the case law backs this up, folks. In Muhammad Ashraf versus Muhammad Afzal, back in 1997, the Lahore High Court basically said what the government document says goes. Unless, of course, you've got some serious dirt on that document, something that screams this was forged in a back alley. Otherwise, public records stand tall in the court of law. Moving on to chapter 4, where we delve into the world of been there, done that with Article 114, all about facts already proved. This one is pretty straightforward, folks. If a fact has already been proven in court, you don't need to prove it again. Think of it as the legal equivalent of, are we still arguing about this? Imagine this, you're back in court for round 2 of the cookie jar incident. This time your defense is that you couldn't have possibly reached the cookie jar because, as proven in the previous trial, you were at a Justin Bieber concert across town. Now, barring some new mind-blowing evidence, like maybe a hologram of you was at the concert, the court's going to be like, yeah, we know. Next. And guess what? We've got a case for that. State v. Shafiqur Rahman, a real page-turner from 2001. The court basically said, look, we already established this whole location thing. Let's move on to something new, shall we? It's about efficiency, people, and not relitigating the past unless absolutely necessary. And finally, we arrive at the pinnacle of obviousness, the creme de la creme of dumb moments in the courtroom. This is Article 115, where we talk about notorious facts. These are the truths so universally acknowledged, so deeply ingrained in our collective consciousness that even trying to dispute them feels like entering a Monty Python sketch. We're talking about facts like the earth is round, flat earthers, you're not winning this one in a Pakistani court. Or water is wet. Unless we are talking about those fancy hydrophobic coatings. But I digress. These are the things that make judges slam their gavels and go, next case. Please tell me we have something more stimulating to discuss. And of course, we have a case for this. In Muhammad Seed versus the state, back in 2007, the court basically shrugged its shoulders and said, look, everyone knows Eid is a big deal in Pakistan. It's a national holiday. For crying out loud. No need for expert testimony or a cultural analysis. It's just known. So, there you have it, folks. A crash course in the facts you don't need to prove in a Pakistani court, thanks to the Qanoon-e-Shahadat Order of 1984. We've talked about everything from government gazettes to the undeniable roundness of our planet. These judicially noticed facts are all about keeping the wheels of justice turning, avoiding unnecessary delays, and focusing on the matters that truly deserve our attention. It's about acknowledging that some things are just common knowledge, accepted truths that don't need a team of lawyers to validate them. So the next time you find yourself in a Pakistani court, hopefully not, but you never know, remember these articles. They might just save you some time, some money, and a whole lot of unnecessary explaining. Until next time, stay curious, stay informed, and remember, even the law has a sense of humor, sometimes.